Hello. Welcome to this week's episode of Mayor Brown's Quick Insights on Congressional Investigations. I'm Andrew Ullman, a former Republican chief counsel of the Senate Banking Committee. I'm joined by Michael Levy, a white-collar defense attorney and former federal prosecutor. Each week, we answer a new question about congressional investigations of interest to in-house counsels and government affairs executives. This week's question stems from a recent D.C. Circuit decision where the court had to decide if a congressional subpoena was enforceable. On first impression, this seems like an unusual question to come before the court. It seems odd that a congressional subpoena would not be enforceable. So, Michael, the question for you is, are congressional subpoenas enforceable?
Well, as you alluded to, Andrew, the answer is a lot more complicated than you would think it is, and it's been litigated multiple times. In fact, it's still being litigated before the D.C. Circuit, just in connection with the House Judiciary Committee's effort to obtain the testimony of former White House counsel Don McGahn in connection with its impeachment inquiry. Two quick observations before I delve into the case law. First, as we've said before, and this is just the latest example, most judicial decisions around congressional investigations arise in the context of congressional investigations of the executive branch that raise certain separation of powers concerns. There are relatively few judicial decisions that relate to congressional investigations of private individuals or entities. Second, you may have noticed that Donald Trump is no longer the president. The House Judiciary Committee is no longer conducting an impeachment inquiry, and indeed, an entirely new session of Congress has begun. The D.C. Circuit has scheduled its second rehearing en banc in this case, and as you know, it's rare even to get one rehearing en banc in a case, for February 2021. But it's asked the parties to brief the issue of whether the subpoena to McGahn has expired and the issue is therefore moot. And obviously, the Supreme Court hasn't weighed in on this, so the answer remains very unsettled. Nevertheless, I think it's worth taking a look at the multiple opinions of the D.C. Circuit in this matter. Before even getting to the substance of the subpoena enforcement at issue, the D.C. Circuit has addressed two preliminary questions. First, does the Judiciary Committee have Article 3 standing to seek judicial enforcement of a congressional subpoena? And second, does the Judiciary Committee have a cause of action? On the question of standing, initially, a panel of the D.C. Circuit decided 2-1 that for separation of powers reasons, the committee lacked standing to seek judicial enforcement of a subpoena directed to the executive branch. The D.C. Circuit as a whole, however, then vacated that opinion, agreed to rehear the case en banc, and in a 7-2 opinion, with the two judges who were in the majority of the panel now writing dissents, two judges recusing, and the judge who was in dissent in the panel, now writing the majority opinion en banc, found that the committee did in fact have standing because the committee was injured by McGahn's defiance of the subpoena, and the matter was capable of resolution through the judicial process in a manner that the D.C. Circuit thought was consistent with our system of separated powers. But the en banc panel then remanded the case back to the original panel to decide the second question, whether or not the committee had a cause of action. That panel, in a 2-1 ruling along the same lines as that panel's first decision, found that the committee did not have a cause of action to seek judicial enforcement of its subpoena. Its reasoning rests largely on the fact that in 1978, Congress passed and the president signed legislation that gave the Senate, but not the House, express authority to seek judicial enforcement of a congressional subpoena. The panel's reasoning was that by implication, the House does not have the authority that the law gave to the Senate, but not the House. The panel emphasized, though, and this is important, that just because the House may not have authority to seek judicial enforcement of a subpoena to the executive branch does not mean that the House is left impotent with absolutely no power to enforce any of its subpoenas. The House can use its inherent contempt authority, basically locking people up at the Capitol, or it can seek statutory criminal contempt, but that requires action by the Justice Department. So, as should be clear by now, we haven't reached the end of the story. We may or may not find out in February 2021 what the full circuit thinks about this. So we just have to stay tuned.
So, Michael, what does this actually mean in practical terms for private parties who are the subjects of a congressional investigation?
I think, as I made clear before, there's a reason why not a lot of litigation and case law is around private parties or private entities subpoena enforcement issues, because for the most part, Congress has so much power outside of seeking judicial enforcement, the power to embarrass, the power to pass regulations or pass legislation that would be harmful to particular people if they challenge the request for documents, that overwhelmingly, as we've discussed, these matters are worked out between the committee and counsel for the entity in a way that gets the committee what they really need and protects the company as much as possible. And working out those things is far and away the best for both sides. And obviously, it eliminates the need for Congress to seek judicial intervention in a situation like that. I don't think most companies are willing to push the issue that far.
Yeah, and as we talked about before too, is that from the congressional investigator side, the time it takes to actually go and enforce a subpoena really undermines with the purpose of their investigation, which, as we've also talked about before, usually runs on a pretty short time frame. So both sides really have an interest in coming to an arrangement with regard to any documents that are being sought out by the congressional investigators.
But it's still interesting case law to look at from a lawyer's perspective.
Oh, certainly, certainly. Well, thank you for joining this week's Quick Insights on Congressional Investigations. We'll see you next week.